Hello, everyone. I'm really excited to be talking about a very important and timely topic today. And our topic is the First Amendment and privacy law. There are quite a number of cases that are going on right now, including two cases before the Supreme Court, one case before the Ninth Circuit, dealing with the impact of privacy law and the clash between privacy law and free speech. And with me, I have Gautam Hans, a professor at Cornell Law School, and he wrote an amicus brief in the case of NetChoice versus Bonta, which is a case now before the Ninth Circuit. It's a case challenging the California Age Appropriate Design Act, or CAADC, which is a law that regulates platforms and requires them to take a number of measures to address content to children, to engage in age estimation, and to do a number of things that are standard privacy law type of things, like risk assessments and notice and other things like that. But to start, Gautam, I'd love to get some background from you on these cases, these cases with NetChoice. So first, what is NetChoice and what are the laws involved in these cases? Because they're different laws.
Absolutely. And thank you so much for having me, Dan. I'm really honored to be here with you all today. So NetChoice is a trade association, a group of technology firms. Think of the companies that come to mind when you think of the tech industry: Google, Meta, etc. And they have filed suit in a number of federal courts on a variety of issues in recent years. So the Bonta case, which you mentioned, that's currently in the Ninth Circuit, as you say, that was a challenge to California's recently enacted privacy statute that regulates the practices of technology companies. And in the Supreme Court, the cases that people may be familiar with, the Florida and Texas social media regulations. NetChoice also filed suit in Texas and in Florida challenging those laws on First Amendment grounds. Now, the California law is a privacy law. It tends to regulate data practices and the practices of the companies in collecting information and regulating the privacy practices of those companies. And the Florida and Texas laws are content moderation laws. Those laws are not about privacy per se, although there's some privacy issues, of course. But those laws really create some mandates and requirements on how the platforms moderate their own content that they host. So there are First Amendment challenges to both, different strands of the doctrine that we'll get into. But that's sort of the high level of how these cases have come about. I think there's some interesting political reasons, I think, that you might see that it's NetChoice versus Bonta versus, as opposed to Google versus Bonta, right? That having a trade association helps maybe to sort of universalize the issues across the industry, and one firm doesn't necessarily take on the lead as the public face of the First Amendment challenge.
Yeah, so I think it's interesting. The laws are different. I think that the Florida and Texas law are kind of one flavor, and then the law in California is a different flavor. And I think all these cases are very significant because they really are going to the laws are related enough with First Amendment issues that I think we're going to have implications from all these cases on not just issues of content moderation, but also issues of privacy law, and that gets into the Bonta case. But I guess quickly, I'd love to get your thoughts on if you could tell us a little bit about what does the CAADC do exactly? What are some of the highlights of that law? And then what are the laws in Florida and Texas? What do they do? Just some of the highlights of what these laws are trying to achieve.
Yeah, so the California law, and I'm speaking from memory, so hopefully I don't make any mistakes. But the California law was imported, I think, from a UK law, and it really regulates how the companies can collect data, how they can use data, and there's particular concerns about children's privacy. As people know, there's the federal CAPA, the Federal Children's Online Privacy Protection Act. This is a state law that does and makes some similar moves in sort of achieving some of the classic goals of privacy law by making sure that there are specific limitations on what data can be collected, how you can ensure that the users are of the proper age, because some parents may not want their children to use these websites without permission. And then there's questions about how the data is retained. And in the Florida and Texas laws, the content moderation laws, we see restrictions on how platforms can remove users, whether they can remove sort of limitations on removal for maybe political speech or disagreements with what the platforms want to have posted, the sort of must carry obligations, if you want to think about it in sort of classic telecommunications ways. And then there's also some transparency requirements that the platforms publicize how many users they take down and what the content moderation practices are. So here you see the states are basically trying to ensure from their perspective that platforms operate in certain ways, that they don't discriminate on the basis of content, and also that they are open about what their policies and standards are.
So, some background, a little bit about the First Amendment, because the First Amendment is just so much doctrine. It's so unwieldy. There are quite a lot of lines of cases that are raised by these decisions, but in particular, there's some important privacy cases in the First Amendment. One that I think a lot of folks are familiar with is the Sorrell case. There are other cases that address, to what extent are platforms speakers? Do they have First Amendment rights? Are there other First Amendment rights implicated? What about the rights of the listeners, or the people who are the users of a platform? Versus the owners of a platform, and we have a lot of different things in the mix. And then we also have the CDA Section 230, the Communications Decency Act 230, which it's not the First Amendment, but it's a law that is interpreted by the courts as a means to protect free speech online, which immunizes providers for speech on the platform by others, but it raises issues of exactly who is the speaker of this, who has the rights, and so I want to get your thoughts on some of the legal background before we start diving into the case. What's Sorrell all about, and kind of what are the rules there? Are there other cases and doctrines that we should be aware of to really understand how the courts are going to think about the cases before them, these three NetChoice cases?
Yeah, so just starting at a very fundamental level, the First Amendment is a constitutional protection that limits the government's ability to regulate speech, amongst other things. There's the religion clauses and association and things like that. But here we're focusing on the speech issues. So what that means is that the First Amendment doesn't limit private entities. Private entities in general can, have their own speech limitations, absent some other, principles that might come into play. So what the First Amendment has done is really made it very difficult for the state to regulate on the matter of speech. The state cannot tell newspapers that they can't report on the presidential election, for an obvious example. So how this ends up playing into digital technology is that there are questions about what constitutes speech. So we mentioned the Sorrell case. This is a case from about a dozen years ago now, where Vermont had passed a law that regulated the use of information by detailers in the in the pharmacy industry. So basically, how could patient information be used and transmitted? So what Sorrell highlighted was a long running question about whether or not information or data in and of itself was speech. So traditionally, economic regulations of business have not really been subject to constitutional scrutiny. And this is sort of what we think of as the settlement from the New Deal, that individual rights would be protected, but corporate rights are not the same thing, that economic rights are different. That had started to collapse in the last, 50 years, and there have been now sort of a relaxed standard of scrutiny for commercial speech, that commercial speech still receives First Amendment protection, but it's less than individuals or like the newspapers that I mentioned before. So then we get to a case like Sorrell, where the law is making distinctions about what different entities could do with the data, and how certain entities were disfavored versus other entities being not covered by the law. And the court looks at this and says, well, information, arguably is speech. There's some language in the opinion that sort of implies that all information is speech. And if if the court deems something as protected speech, then any law that regulates speech is going to come under First Amendment scrutiny. And the reason that this can be challenging is that the courts are generally very skeptical of laws that regulate speech in any kind of way, precisely because of the First Amendment's broad protections. So what that means is that if information is categorically First Amendment protected speech, then it's going to be very difficult for the government to pass any kind of laws that regulate information, because the regulated industries, the tech companies in the Bonta case, for example, will say, well, you're regulating data. Privacy fundamentally is, regulation of information, regulation of data. If data is speech, then we end up in a situation where regulations of privacy are First Amendment issues. And as soon as you start raising those claims, the courts tend to side with the challengers to the law and say that's not permissible. So the Sorrell case, is a little bit hard to parse, and there's been a lot of scholarship. I've written some, as have many other folks, arguing on various sides of whether or not Sorrell means that every privacy law comes under First Amendment scrutiny and thus has a hard road to constitutionality. I think that what makes Sorrell a little bit difficult is that the case, I think, is a bit of a Rorschach test in my mind. So on the one hand, the Vermont law at issue, the court seems to imply wasn't particularly well drafted, that this treatment differentially of different entities, created some suspicion on the part of the court, but that other privacy laws, the court mentions HIPAA, the health privacy law that people may be familiar with, as a different type of law, almost implying that, HIPAA, that's a good law, that's the privacy statute, but it's well constructed, it's sort of a broad, regulation that has different pieces and has been more well thought out than the Vermont law, which is, maybe not as good of a law. The Vermont legislature maybe didn't do as good of a job as Congress did when it drafted HIPAA. So that's kind of maybe one of the pieces of the Sorrell case that argues against the claim that all information regulations are speech regulations and therefore subject to First Amendment scrutiny.
So yeah, I mean, my take on Sorrell is very much consistent with yours. I think when it came out, folks were saying, "Oh my gosh, this means that most privacy laws violate the First Amendment." But I think Sorrell was very clear that there was a line that was crossed, and that was the big line is don't discriminate against particular viewpoints. So, if a law is neutral as to viewpoints, it's okay. If a law singles out certain types of messages on certain particular views, that's a no-no. And so the court said, look, this is just focusing on pharma companies, and it's limiting pharma marketing speech, and that is singling out them to be treated more disfavorably than other speakers on other matters. And so the court really hammered that. And that's why I think it said the HIPAA's okay, because HIPAA's very broad. It covers health data no matter who is talking about it. And so in a way, like the bigger and broader your law is, the more you try to cover. If you regulate the universe, that's actually better than if you try to be more narrow in your law. So, a bigger, more powerful, muscular privacy law like HIPAA, which covers a lot more, and it's actually much more restrictive in a lot of ways than the Vermont law, is actually okay because it doesn't cross that line. So in a way, like, go for the more comprehensive privacy law. The broader you can make it, the better. But that's sort of, I think, the lesson I take away from Sorrell is, just don't cross that line and you're okay. But otherwise, you're fine. Legislate away, and you can create more HIPAAs, and that's okay. But the Bonta case. So we have the California, passes the age appropriate design code, and in a way, it's trying to limit it. I mean, it could have passed, instead of the age appropriate, just the design code will regulate all websites and make the requirements of the design code apply to everybody. But instead, no, they thought, for various reasons, we'll have it more narrow and we'll target it to children. And so part of the law then is the targeting to children, okay, but this then raises some First Amendment difficulties in that when you how do you limit the law to children? How are websites to know when children are there? We have the Children's Online Privacy Protection Act, a longstanding federal law that regulates children's privacy online, and it works. It's triggered. It applies to websites for children under the age of 13, and it requires either actual knowledge that a child is 13 or younger than 13, or if the website's directed to children under 13, if by its content and what it's doing, it's clear that the website is for kids under that age, then it's covered. So either you have knowledge or it's that. And then it has a whole host of the privacy requirements like, notice and, security and limitation of use of data. And, there's even, a deletion in that, one of the early US deletion rights. And that law hasn't, it's been fine. It hasn't really, really triggered any First Amendment pushback on that particular law. But the California law works a little differently. The age is older. I think it's 18, if I'm correct. I'm not sure. 18 or 16, I can't remember. But it does. It doesn't have the same trigger. It has age estimation, and this, I think, is the concern of NetChoice and the companies was there's certain things in this law that are going to be difficult or burdensome to comply with. Then we also have the court's opinion, which kind of goes way, way, way beyond I think what it should do and gets into, I think, almost to an absurd territory, but we'll get to that. But I wanted to get your thoughts on what are, at least initially, what are some of the aspects of the law that, kind of most sensibly are the things that are difficult First Amendment questions versus what did the court do? Because the court kind of went way beyond what it needed to do in certain ways. And that's complicates the matter because there's a lot more things at issue now in this case than probably would have been an issue before the court made its ruling.
Yeah, so number of things here. I think that certainly the fact that the law is regulating, like, a specific portion of the population, children, as opposed to, all, users, creates an issue that can be hard for California to defend. It's an issue that's similar to what you said about the Vermont law and Sorrell, which is that you're making distinctions as opposed to having broad coverage. So I think that that is something where, um, California has faced some challenges, and those who are up on the history of technology law and First Amendment challenges may remember that there were several laws in the 90s and the 2000s, federal laws that were challenged on First Amendment grounds that dealt with children's privacy that the courts did overturn on First Amendment grounds. COPPA has survived, but there was COPA, COPA, and CHIPA, and probably other ones that I'm forgetting. And so all that to say that, this is something where the laws are contested. COPPA persists, but not every children's privacy law at the federal level has. And so that, I think, can pose some challenges to to California in this case. I think, though, that part of the reason that we wrote the amicus, and I hope if we haven't mentioned this, the background is that I and Margot Kaminsky of Colorado Law drafted an amicus on behalf of a number of First Amendment law professors, privacy experts, Dan being one of them, arguing to the Ninth Circuit that California's that the district court erred in its analysis in granting the preliminary injunction against enforcement of California's law. And the reason is not particularly because I've had strong feelings about this specific law, but it's to what you mentioned, Dan, that the district court decision in this case, I think, was way too broad, and if taken to its logical conclusion, could actually invalidate laws that I don't think should be invalidated on First Amendment grounds under the reading of Sorrell that you and I have been discussing. And another way of saying is that I'm not so much concerned about this law, but I am concerned about this district court decision being very threatening to all sorts of other laws, both in California, in other states, and federally, that either have been enacted or have been contemplated that would regulate privacy. The district court was very skeptical of applying intermediate scrutiny, and I think did not even properly apply intermediate scrutiny in this case, and rather it applied strict scrutiny, the most stringent constitutional test, to invalidate the law, even though it claimed to be applying intermediate scrutiny. And it also, I think, missed a key point, which is that Sorrell was decided, about a dozen years ago. And then, we've seen many challenges to other privacy and data regulations on First Amendment grounds. And what's happened? Almost every court that I know of, at least, that has contemplated a First Amendment challenge to a state or federal privacy or data regulation has upheld the regulation on First Amendment grounds. Why is that? I think there's a few reasons. One, the laws at issue, the Fair Credit Reporting Act, Illinois' Biometric Information Privacy Act, and then a Maine law that regulated the privacy practices of ISPs, internet service providers. These laws, I think, were quite different than the Sorrell law. So I think that they were better drafted in the ways that are more like HIPAA, more comprehensive than the Vermont law and Sorrell. And secondly, and I think as a matter of political economy, courts realize that this is a vast industry that they have to be very mindful of sort of upending. If a court writes an opinion saying that states or Congress can't regulate in privacy areas, they're basically insulating a vast portion of the economy and a rapidly growing portion of the economy, one that pervades all aspects of our lives, insulating that industry from economic regulation, which is, I think, anti-democratic, unwise, and quite unsettling for those of us who are already concerned about the vast power of these companies. So separate from the doctrinal issues, I think there's a sort of realpolitik, sort of legal realism aspect to this, where I think judges realize, do I want to be the judge that says, actually, you can't regulate Google, you can't regulate Meta, or you can't regulate ISPs or Clearview or Experian? I think most judges are quite concerned about that and have found doctrinal ways to distinguish Sorrell from the laws that they have been presented with.
So yeah, there's a lot of issues that I think, to tease out of here. I think one is, do laws that focus on children, is the focus on children, crossing that content-based line? And I think no. I mean, it's broad enough. You can be very neutral. At some point, laws have to be about something, and not everything is a viewpoint. And I'm not sure, children is a viewpoint. I mean, saying like certain specific things related to children could be a viewpoint, but not generally children. So I think of a law that just says generally. Then there's the issue of, the mechanism that a law uses to determine its scope could have certain effects. So, like the age estimation process, when one of the arguments in that NetChoice made was, to estimate age, we are going to have to, gather data about our users. And that process could either be, expensive or difficult or cumbersome, or it could create a chill in the user. So if a user has to put in a credit card, they might not have a credit card, not be able to access the information. Or it could, if they're going to use some kind of a facial recognition AI system to determine, is this a kid or this is an adult, then folks would say, hey, I don't want that. Do I have to subject myself to this in order to get this data on the site? And they might not go to that. But the NetChoice, I'm not sure would have standing for them. I mean, they would be the ones that the audience would be the ones to say, hey, the law is forcing this. And so far the law hadn't even been implemented yet, so companies weren't doing anything. So it seems a little premature until we see what mechanisms are actually going to use to estimate age. There's that whole issue. But then there's also the issue of the specific provisions of the law. And the court went out and said essentially that not only do those aspects of the law raise First Amendment difficulties, but the law's requirements of doing an impact assessment is a First Amendment violation. And this is the thing I find most outrageous about this opinion, is when the court said, look, doing an impact assessment is compelled speech. It's forcing you to disclose your risks. Having a privacy notice is compelled speech. It's forcing you to speak. And the court constantly went back to this compelled speech, forcing a company that's forced to declare its policies and undergo any kind of internal mechanisms to assess risks would in fact trigger the First Amendment. And this is a radically broad view of the First Amendment, one I have not seen before. I think it takes the First Amendment in a incredibly powerful direction that would essentially wipe out most regulation. It would mean that the nutrition labels, well, that's compelled speech, right? Laws that force the disclosure of the calories in meals, compelled speech. Warnings on cigarettes, compelled speech. Warnings on products, compelled speech. Disclosures for SEC disclosures, compelled speech. So, I mean, if the court's right here, my concern is that this would wipe out and make almost any privacy requirement that you do risk analysis, or that you have a privacy notice, or that you make any kind of disclosures to anybody of any sort. All of that would then run afoul of the First Amendment, and it would make it very hard to have any valid privacy legislation, as well as most regulation generally. I mean, this is a way you could truly kill the regulatory state, because there'd be very little you can do if you can't even require a company to do a risk analysis. So that to me would be a very bold stroke, would be knocking out not just privacy regulation, but incredibly large bodies of regulation. So the implications are staggering, and for a court to just kind of almost in a very very kind of cursory way, without even thinking about all these implications, just kind of came in like a bull in a china shop and plowed through, reached all this that I don't even think needed to be reached. There are some tricky First Amendment questions with the provisions about age and others that I think warrant some thought. But this is a whole other dimension.
Yeah, I completely agree. I mean, the thing that I was thinking about was, securities regulation, right? Like, disclosures that companies have to make when, initial public offerings, other kinds of obligations that I, having not taken SecReg, could not tell you a ton about, but know exist, are imperiled by that kind of, reasoning. And I think that there's a number of pieces going on here, but one of them I think is the sort of judicial economy, appropriate role of the judiciary here. This law has never been in effect, to my knowledge. It was endowed, like, NetChoice sought a preliminary injunction against enforcement, which I think, that's well within their rights to do. First Amendment, there's a long tradition of that in the First Amendment. But having said that, a preliminary injunction is an extraordinary remedy. It's something that can be done with a law like this in specific targeted ways. So if the age verification question was truly the most concerning, well then you write the injunction that only enjoins enforcement of that part of the law, right? And maybe in such a way that doesn't imperil all the other kinds of laws that might use similar provisions. So I think there's both the question of sort of the proper role of the judge in this case. And I, not being a judge, I'm loath to say the judge was absolutely wrong and indefensible, but I don't think it was what I think of as the most judicially careful approach, both in terms of the remedy and also in terms of the reasoning, which frankly I find to be the most concerning for the reasons that you mentioned, because you can say that this law maybe has some problems, but I think writing it in the way that the court did just opens Pandora's box and leads to, I think, an outcome that I don't think that the court really understood or really at least acknowledged. And I'm hoping that the Ninth Circuit will be a little bit more cognizant of.
Yeah, I think that it's sort of like the court uses almost like a nuclear weapon to annihilate pretty much any a ton of regulation, when really I think the issues are dealing with age estimation, and I think the challenge though is that age estimation, it's not clear, as you mentioned, is this properly before the court at this point, or is it premature? Are they, because part of their argument is we're going to have to do this, and maybe speculation, if we do certain things, which we think we might, but we haven't even done yet, then people are going to, stop, going to our site. So a lot of speculation upon speculation, because they haven't done it. It's not clear. They're forced to do, the law has a wide range of things they can do. And we don't even know how this is going to play out. But, and typically, in standing, which is a doctrine that I think largely is a kind of, it's a total mess and a bit of a cesspool, and it's not a coherent doctrine. The Supreme Court has said, well, if it's speculative, it's not a concrete injury, there's no standing yet. Now, it seems like courts are used standing. Well, if we want to hear it, we'll cook up something. If we don't want to hear it, we'll say it's speculative. But I think it is going to be difficult to square this with standing. But that said, there are certain concerns with the First Amendment. I think one of the problems is that the law has certain standards about looking out for the best interests of the child, and so it could create certain issues about vagueness, like is it clear enough for companies to know what they're supposed to do and what they're not supposed to do, like when is there something that they need to limit or restrict. That could, I think, create certain problems if it's not specific enough. But there also are ways that courts can construe statutes or fix statutes by limiting their reach and interpretation, clarifying certain things, and saying courts do this all the time with laws. Look at defamation as a great example, where the Supreme Court, essentially rewrote defamation law in New York Times versus Sullivan and the cases that came afterwards to create the actual malice standard, which wasn't in defamation law, and they put it in. They rewrote the law to make it consistent with the First Amendment. This judge, seemed to be, such a First Amendment absolutist. Didn't even make an attempt to try to do that. So I would think that the Ninth Circuit would probably be a little bit more careful about how far it goes, because they're to keep the blast radius of the First Amendment within a reasonable bounds, and then also figure out a little bit more surgically, with more nuance and thoughtfulness, how they should analyze the law, because I think there are certain points in the law that you could trigger certain things. I haven't fully thought them all through, so I don't want to come out and say, yeah, the law's totally fine, or not. I think there are some real questions. There's some difficult questions, but unfortunately, the court, in its opinion, instead of really tackling those questions, went about it with this, this kind of nuclear approach, which essentially, raises all sorts of problems and questions that now I think, the Ninth Circuit's going to have to clean up this mess and then actually get to the real issues. And maybe because the issues are really hard, the court didn't want to get to them. So, if it's really hard to do a more precise surgical analysis of the First Amendment, why don't we just nuke it all and hold every possible regulation and everything unconstitutional in the First Amendment, and therefore, we know we got it. And then you don't have to do the more, tricky, thoughtful, hard thinking to really figure this out. But I'm hoping that the Ninth Circuit will engage in that. I think that was the focus of the brief, the excellent brief that you wrote. And I urge folks to read it. It's a brief I was very happy to be sign on to and be part of, because I think you did an excellent job explaining, just how damaging and broad and unprecedented this opinion is. I want to look at the cases that before the Supreme Court, because these are related but different. As you had explained, Gautam, it involved these content moderation laws, attempts by these states to essentially make it restrict platforms from moderating content. So I guess they can't, take down information if they think it's disinformation. They have to essentially, I guess, almost leave up everything. But tell me a little bit more about your take on these cases, and because the argument's going to be very soon at the Supreme Court, and kind of what's at stake in these cases.
Yeah. So these cases are being argued in the end of February, I believe on February 26th. And as I mentioned earlier, they concern First Amendment challenges to Texas and Florida's regulations of social media platforms and their content moderation practices. And so the laws in Texas and Florida have some similarities and some differences, but the broad question is to what degree the states can tell social media companies that what their content moderation practices should be. And sort of the intuitive hook, I think, for this is that there are concerns about how these, powerful private entities regulate speech. How do they decide what stays up and what stays down, or what accounts are removed and what accounts are not removed? Are they consistent with those practices? Are they, discriminating against specific viewpoints? And if they are, is that a problem? All sorts of things that we would view as, deeply problematic in the context of the government. If the government says that it's only going to give permits for parades to men, that's going to create a very obvious First Amendment issue. By saying, that the government's making choices about who gets to have parades and who does not. But in the context of social media, it's the private sector. And historically, we are in this country less concerned about the private sector's practices than the state. In other constitutional democracies, that's not always the case, but certainly that's true in the United States, generally and historically. But I think what's happened is that we see how powerful these companies have become and how they shape public discourse. And as a result of that large power, there are questions about whether or not they are sufficiently like the state or common carriers like the telephone companies, right? The telephone companies, people say can't discriminate against certain employees. They have to offer service to everyone. So maybe we should treat social media companies in ways that are similar to telephones and think of them as common carriers. I think there are a few issues with that understanding, and one of them is that social media companies have specific vibes or specific goals of what they're trying to promote on their platforms. So the most obvious example is that Facebook and Instagram are really restrictive about nudity. They're very careful to try to prevent users from posting nudity or anything that might be, sexual on their platforms. Obviously, there's lots of problems with implementing that that people may be aware of or think about. The most obvious being art. There's all kinds of famous photographs or paintings that depict nudity that we might think should be hosted on those platforms. But in general, they have a specific view about what kinds of content they want to have that other sites may not have. So that's one piece about why I think thinking of them as common carriers that don't have their own justifiable reasons for making choices about content isn't quite right. Then there's a question about whether or not the state should be able to tell private entities what speech they have to carry and what they don't, and how and why they have to make decisions about their content. And here, the companies are claiming that they are similar to some other entities that have challenged laws on First Amendment grounds, and there's some Supreme Court precedent on these points. The social media companies would say, look, there's this case called Miami Herald versus Tornillo from the 70s, where the Miami Herald challenged the Florida law that mandated that they carry certain editorials. And the Supreme Court said that that Florida law was unconstitutional, that it was compelled speech to force the Herald to publish certain editorials, that the Herald had its First Amendment rights to, create the kind of editorial page and the editorial product that it saw fit to do. This is what I and others, call editorial discretion, that the editorial discretion rights of the Miami Herald were First Amendment protected, and the Florida law violated that editorial discretion. There's some other cases along these lines. There's a case about a parade. A Massachusetts law, an anti-discrimination law, mandated that an individual that discrimination on the basis of sexual orientation was unlawful, excuse me. And the Association of LGBTQ Irish Americans wanted to march in an Irish American parade. The Irish American parade organizers said, no, we don't want the specific group. The LGBTQ group said that's a violation of this Massachusetts law. And then the parade organizers said, well, that law, as applied to us, violates the First Amendment because we should have the right to decide who's in our parade and who isn't. Parade is expressive, it's longstanding, and we should be able to choose who is part of our parade because we're trying to send a specific message, in this case about Irish American heritage and history. The Supreme Court agrees, says, look, this Massachusetts law cannot in this situation be applied to this parade because the parade has sort of First Amendment rights to have the discretion to choose who is part of their parade and who is not. And so the social media companies would say, look, we're just like those categories. We are like the newspaper. We make decisions. We have our viewpoints about what we want and what we don't want. The nudity example being one of them. And the state's interference with that is going to create real problems for us, in addition to creating a First Amendment issue. I should note that I co-drafted an amicus with James Grimmelman and my colleague at Cornell, who really took the lead on this case and this amicus, arguing that these laws implicate the First Amendment rights of the individuals, and that the court should be should invalidate them on that ground. But my major concern with these laws is truly on the grounds that they implicate First Amendment protected rights in ways that I think don't fit with the precedents of the Supreme Court.
Yeah, I find this interesting because part of me doesn't like these laws. I think that they are laws that are really geared to trying to open the door to a lot of misinformation and harmful speech that could hurt people, and that it's important that platforms be able to create a safe environment and an environment of truth on their platforms. That said, a couple of problems is one, there could be platforms where, if we say they are the speakers and they control it, then it's the decisions of the billionaires, so one billionaire says, like Musk, like I want the disinformation, I want the bad stuff, like bring it on. And then we're stuck with that. And then we have these really powerful people essentially, having, tremendous sway and influence by controlling a few platforms, which is the argument, well, maybe the platform should be a kind of, a public space and they can't do everything they want. On the other hand, because we want to just hand them the reins to do all the speech. Another thing is, the platforms are, not just moderating content, but they decide, through their algorithms, the content that each person sees, that content, those algorithms work in certain ways. And it sometimes promotes stuff that is, more polarizing, triggering the emotions and likely to spark kind of mob-like behavior online and so on. And we've seen a lot of studies that, the way the algorithms work is they're trying to, ramp up engagement. And that's typically, leads to, polarization and to a lot of, problematic things. So the law, a state might want to regulate them and say, hey, maybe you can't do anything with your algorithm. And maybe you have to be mindful of, protecting against hateful speech or speech that could harm another person, or threats online, or disinformation, and states might want to regulate there. And so if the Supreme Court holds very broadly, like everything a platform does, from the speech it does to the content moderation to the algorithms that order it, all that's them speaking, that then makes it really hard for a state that is engaging in, I guess there's content moderation that I like, which is, protecting against disinformation and harmful stuff, and content moderation I don't like, which is, well, let's let everything happen. I am concerned too is, well, one person's, what if a state decides that the false information is true, and they want to force, the platforms to omit the true and do the false information. Is an argument Jeff Kosseff makes, is that, careful what you wish for, because it could be really dangerous if states regulate in a way that, we're envisioning states regulating in a way we like for content moderation. What if they don't? And then I think there's a really interesting issue with Section 230. And that is Section 230 applies to the content, it immunizes for the content of others. So if I'm a platform and you post something on my platform, Section 230 would immunize me from things you say. But if I'm saying it, if I'm the speaker, if I have the platform, so on Twitter, if Musk posts, Musk can be sued, right? And then the question is, well, what turns the platform into a speaker? Now, what's weird is when we're looking at these First Amendment cases, NetChoice is going and saying, look, we're the speaker. Everything we do is speech. The way we moderate, the way we curate, the way our algorithms work, all that's protected speech. You can't regulate it because we're speakers. We're speaking through the algorithms and through our content moderation. It's speech. And then for 230, they'll turn around and they'll say, no, it's not speaking. We're just a platform and people are just putting it there. And we're not doing enough to be speakers because we don't want to be speakers for 230. So I kind of think there might be a tension here. Are they speakers? Or are they not speakers? What are they? And I kind of think we're in a weird, like betwixt and between type of scenario. There is a speech component. They are speakers, but they're also, it's not the same as the person who posts it, but they are doing a lot to encourage certain types of speech, to shape discourse through the way their platforms are structured, their algorithms. Some sites actually encourage certain types of speech. These sites that encourage people to post hateful things about others or post nude pictures of other people. And there are a lot of these sites. This is something Professor Daniel Solove writes about. These sites are doing more than just passively sitting there saying whatever you want to post. They're actively soliciting and encouraging people to post this terrible content on their site. And so I wonder, how this gets resolved, because I think there are some implications for 230. There are implications for what states could regulate. There's implications for, content moderation to some extent too. And for, I think, the CAADC, which is, has some content, moderation components to it, some content restrictions that they have that could be also implicated, I think, by some of these cases. So curious what your thoughts are on all these tensions, because I think that I kind of see there are problems on both sides where part of me says, hey, I kind of want NetChoice to win at the Supreme Court against some of these laws because I like sometimes when they are trying to moderate in these ways. On the other hand, I could also see some big problems if they do that too.
So I have 8 minutes to resolve all of these things. We'll see how far I get. So a few things. Speaking about the net choice cases in the Supreme Court, what I would say is that I think that the ideal outcome from my perspective is a ruling for net choice that does not sort of salt the earth on any kind of content moderation law that a state might contemplate or that Congress might contemplate. I, depending on what the law is, I think that there are more or fewer constitutional issues that could arise. So, for example, the transparency provisions in the Florida and Texas laws are not at issue in these cases. That I think will come for another day. And I don't think that transparency reporting in general should be unconstitutional. So I'm glad that the court has deferred that question, although I suspect that it's going to come up anyway because it's hard to sort of disaggregate. On the questions about what content moderation policies are and how they're enforced, I personally am okay with disclosure in general about content moderation policies. I'm more concerned about mandates for removal, precisely for the reason that I think you mentioned that Professor Kossoff has pointed out, which is that saying, for example, that platforms have to remove things that are misinformation, creates all kinds of enforceability and line drawing issues because what misinformation is contested. Now, I don't mean to argue that I think there's no meaning out there, that truth doesn't exist, but in general, the courts have been really skeptical of legal mandates on platforms having on things that have to do with speech precisely because of the concern about state control over discourse. And so I think that it's going to be very difficult for a court to say, given the history of the First Amendment and its in doctrine and what what the Supreme Court has said over the last century about the First Amendment, that state laws or federal laws that sort of are really targeted about regulating information don't pose First Amendment problems. However, I think we have to be mindful of the benefits of experimentation in the states, the laboratories of democracy theory, and I would hope that the court does not forestall broadly the ability of states to sort of experiment with thinking through, is there a way to write a constitutional content moderation law? I'm skeptical that there is, but I'm not willing to say that there is not categorically. And I think it would be good for us to sort of figure out what to do about this massive problem. Again, going to the sort of social and political and economic power of these platforms, to say, well, we can't do anything about it because of the First Amendment, I think is, intellectually dishonest and I think practically and democratically bad. On the 230 point, I think that there's appeal to the argument that it's inconsistent for the platforms to say, for the purposes of 230, that they are not, speaking, and then for the purposes of Texas and Florida social media laws, that they are speakers for First Amendment rights. I think the difference here is that the goals here, I think, are really to be speech maximizing. One way to think about 230 is a law that is supposed to maximize online speech and communication, and that the immunity grant is a necessary prerequisite to make platforms come into existence. And without it, you would really have entrenchment by a few players with a lot of money who can afford to have deal with the litigation costs or the enforcement costs. And that the First Amendment doctrine here is also supposed to maximize speech in the context of Texas and Florida, because we want to have a situation where we're having lots of different viewpoints without states saying what's permissible and what isn't for platforms to carry. Having said that, I think the platforms, I think for some economic reasons and maybe some, public relations reasons, have really tried to obviate and downplay their role in content moderation, precisely because they don't, I think, want to highlight for the public or draw attention for the public how much of this truly is discretionary. And that's disconcerting, I think, to think that really this comes down to some individuals making choices about what's allowable and what isn't. But that's exactly what this all is. And I think the discretion in the hands of the billionaires or the people who the billionaires employ is something that we should all be really concerned about, understandably so. But content moderation and speech policies at a fundamental level often do come down to discretion, as uncomfortable as that is for all of us. And I think that's why the transparency pieces of this are really important for me, because even if we have to, be comfortable with discretion in this context, I think we should at least know how that discretion is being utilized and how it has changed over time and what standards are being practiced. And transparency, I think, is maybe the most effective way right now to get at that solution.
Yeah, I would probably take a little stronger view because I'm a little more critical of 230. Actually, if 230 were just the words that it actually says, I'm agreement. I think a platform shouldn't be responsible for the content of another. But the courts have extended it and interpreted it to wipe out distributor liability, which it actually does not do on its text, and I don't think that was its point. But basically, to wipe out distributor liability, which is even if a website knows or should have known that something is invasive of privacy or is defamatory, that then they can still keep it up there and don't have to do anything. And I think that's different. And I also think, even as it's drafted and interpreted, 230 is limited to, it does not immunize a site for its own speech acts. And then the question is, how far do we interpret that? And I'm more sympathetic to the civil litigation system, hashing some of those issues out. A user is harmed by something invasive of privacy. Someone posts a nude photo of someone. I think they should be able to sue the platform if the platform encouraged it, if the platform knew about it and didn't do anything about it. I think all those should be things that should not be protected by 230 in those cases. I think that encouraging it or facilitating it, promoting it, that turns the platform from the passive receptacle of speech into more actively shaping and pushing this material or trying to generate it by soliciting it. And I think that they should be able to be sued and not be protected by 230. But the danger, I think, is that if we have a very overbroad 230, which immunizes them from any private suit, and then we have a thing in the Supreme Court that says, okay, they are free to do whatever and say whatever they want. Then they have kind of the double-edged sword to go out there and do all sorts of harmful things to people and with impunity to promote solicit, do all this stuff and get away with it. But I do think too we don't want state laws that prohibit them from being able to moderate in certain ways. So how to walk this tightrope or carve this thing is going to be really tricky. And I haven't fully figured it out exactly how to, balance these things, because I think there are dangers on all sides of this issue, which I think you've acknowledged and very thoughtfully. I hope that the court will, come out with some brilliant answer. Let's hold our breath and maybe not hold our breath, because I'm not sure what's going to happen. But maybe they'll do something pretty narrow, and which I think is probably the best thing, is just to say, like, these laws and this approach is too far, but try to avoid saying anything more than that, and really try to cabin their opinion to just that, because I think that trying to over resolve things could make a mess of things when this is a tricky issue to figure out. So we're at the hour. Thank you so much for joining me. I've really enjoyed chatting with you about this, and your background about all the cases and what's going on, and your thoughts about it were really excellent and clear. And I think that I just want to thank you for all the insights you brought to today's discussion. So thanks, and goodbye, everyone.
Absolutely. Thank you.